Well, I got into writing Canadian building contract because Manny Goldsmith, who, if any of you met, was a wonderful, wonderful man. And he wrote the book Goldsmith on Canadian building contracts, and then he came to our firm, and then I wrote it with him for 15 or 20 years, and then he died, so I've been writing it for the last 10 or so years, and then I brought out a 5th edition, which is a complete new book a couple of years ago. So I've thought a lot about the issues that face construction lawyers and in drafting construction contracts. And I do put out a blog on both construction law and arbitration, which you can go onto the 2 websites. And if you read those blogs, I actually think about the case. It's not, I don't like blogs where people just sort of say, here's something, bingo, a paragraph, and that's it. These blogs, I hope, are thoughtful analysis of a particular case that's come up. So that's why I get into this idea of what are the 10 most important issues that are facing us right now. And the title Top 10 is probably not the right one. We're just going to blue sky what the law of construction contracts is in 10 areas. They're intended to be cases you might not have looked at or cases you might not have thought about in the way that I'm going to talk about them. And they're recently reported cases, many of which I'm sure you'll hear about this week, but let me have a shot at giving my thoughts about some of these cases. So issue number 10, ripple impact and acceleration damages. I think this is one of the most difficult areas of construction law. It's an area that is known to construction law more than any other area. The idea of, I mean, what are ripple or impact damages? They're damages that arise from the breach of one particular element of the contract or one particular incident that have a vast impact on the project. And the experts that you must have to prove acceleration or impact or ripple damages are legion. So it's a very difficult area of the law, and it involves vast amounts of money. I mean, the damages in this area can be huge. So when I came across these 2 cases from Quebec, they were first written in French, and je parle un peu en français. And so I read these cases, and I said, these are really, really important cases. They're both cases dealing with Hydro-Quebec managing. Some might use a much stronger word because Hydro-Quebec got dinged a big amount of money in these cases. And they both involve large contracts. The Daco case involves the rehabilitation of the Beauharnois generating station. Daco was the main contractor, and Solomec was a subcontractor, and alleged that Hydro-Quebec had really operated this contract in a very unfair way, over 400 change orders, etc. And so Solomec had a big claim, although it was a subcontractor, which was asserted by Daco as the main contractor against Hydro-Quebec. Court of Appeal awarded $2.5 million in this kind of damage against Hydro-Quebec. I guess Hydro-Quebec gets no respect in its own Court of Appeal. It loses oftentimes big time in the Quebec courts. Construction Kiewit case was the construction of the Grand Mire hydroelectric dam, 5-year project, and Kiewit claimed acceleration and impact damages due to the misdesign of the project, and then, of course, the inevitable huge number of change orders, and then the owner saying, by the way, you've got to stick with your original schedule, and what the court said, taking advantage of the contractor through that process. So if you want to read, I mean, these are long judgments. When I first read them, they were in French. They've now been translated into English. They provide a good factual background to acceleration or impact damage cases. So if you want some ideas about what fits into this kind of a claim, go to these cases. They give you good ideas. And secondly, there is excellent legal analysis. And as far as I'm concerned, the civil law and the common law in this area are no different. And you'll find some very good analysis by the trial judge, first of all, in each case, and then the Court of Appeal. So, for instance, in the Daco case, the court analyzes what is impact damages? What are impact damages? How do they differ from indirect and direct costs? And what terms in a contract, or more particularly in an amendment to the contract, can preclude a claim for impact damages? And in Daco, the Quebec Court of Appeal said that impact damages are not I'm quoting from the judgment, not particularized costs of a change, but rather consequences in terms of additional costs that a change may have on the rest of the project, or which result from delays or failures from the providers of the work. Impact costs are, in a fixed price contract, normally the responsibility of the contractor. So think about that. Normally, in a fixed price contract, impact damages are the responsibility of the contractor. But if they arise from a breach of contract, then of course they're recoverable by the contractor against the owner. Or as the court said, in this situation, impact costs resulting from changes and delays are the responsibility of the person providing the work, i.e. the owner or the contractor. And the court distinguishes, I won't go through, the difference between indirect and direct costs and impact damages, but says that in some cases, impact damages can be direct costs or impact costs or indirect costs if they arise from a consequence of a breach of contract rippling through the whole contract. So the Daco case is in Daco, the Hydro-Quebec, in his change order, said, we're not going to pay you for indirect costs. They didn't say that, but in effect, the change orders did not provide for indirect costs. I'm sure Hydro-Quebec thought that by that they were eliminating it. Not so. The Court of Appeal said by not dealing with indirect costs, it left Daco with a claim for indirect costs at the end of the project. And the court said the amendments did not regulate the impact costs resulting from delays. And then the judge carefully reviewed the evidence, both documentary and testimony, to arrive at this conclusion. The court shares this view and believes that the context of the negotiations and the conduct of the parties indicate the negotiations on impact costs were postponed. There never was an agreement on this issue, and the receipts are not intended to cover impact costs. So if you're negotiating changes to a contract involving a large number of changes, you should direct your mind to whether the document that you're signing is going to negate or not impact costs. The construction Kiewit case, again, it's a good example of the ingredients of acceleration and impact damages. I'm just reading from the judgment. General loss of productivity, delays in acceleration of work, concreting during winter time, additional costs for technical staff, supervision, indexation of delayed work. So a huge variety of things that fell within a claim for indirect costs and acceleration. Court said, of course, the first thing the contractor has to do is prove the connection between the breach of contract and the damage suffered by the contractor in all these ripple and acceleration ways. Court says, before analyzing each of Kiewit's claims, it is helpful to question its right to claim such damages. Indeed, to be compensated for delays, Kiewit must prove that these are attributable to Hydro-Quebec or caused by Hydro-Quebec's default. So the court went through that in great detail and found that they were caused. And in fact, this is a wonderful judgment about an owner abusing its authority. And the trial judge said that the Hydro-Quebec during the project used beautiful words to cause Kiewit to do all this work. Said, oh no, you'll get paid, don't worry about that. And at the end of the contract said, this is what the contract says, you don't get paid. And the Court of Appeal said the trial judge was fully justified in saying that those beautiful words had led to a reliance by Kiewit, and it didn't get everything signed and I's dotted and T's crossed, but it was entitled to payment for its impact costs. So, two really important cases in my view on that first issue. Mitigation and causation. Well, we're all familiar with mitigation and causation, but the only purpose of this discussion is to have you remember that there's a difference between mitigation in the case of a company, a construction company, which can take on a variety of work, and a person, an employee, who can only do one thing at a time. And the cases are clear that, so the issue here is, if a contractor takes on another job, is that in mitigation and therefore has to be deducted from its claim? Or could it have done that work anyways, and therefore that work and that profit does not have to be deducted from its claim in the present case? And the point of the discussion here is to bring your attention to the Karras and Rowlett case, which from the mediations and arbitrations I've done, this becomes a real issue. When does other work have to be taken into consideration in mitigation of damages? And just remember that the Supreme Court said in the Rowlett case, that the Karras and Rowlett, that a contractor is different than a person. Yes, if a person takes on another job, or does another job, it's presumed that that replaces the other work that he was terminated from, but not so in the case of a contractor. In prima facie, new work in the case of employee replaces the work that the employee was doing when terminated. And in the Karras case, the court referred to an Old English judgment where the court said, because they could, if they had minded, have performed both the contracts and made the profit on both the contracts, but for the breach by the Vic Mill Company of their contract. And the Supreme Court of Canada in the Karras case said, this contractor is entitled to the full profit on the job from which it was terminated, and the other work that it had was not to be taken in mitigation. That case has recently been applied in the reverse in the 690981. Not a construction case. It's a case of termination of a cable company. I think it was Bell or Rogers, from a apartment building, and being replaced, or that was the issue, by another cable company. And the question was, one in replacement of the other or not? Court went through all of this law that I'm now discussing with you and held no, yes, this was in replacement. The new contract with Bell or Rogers, whichever it was, would never have come into place had it not been for the termination of the prior contract. So I think it's an important issue for you to bear in mind anytime you're going after damages or resisting damages in a construction contract situation. Okay, issue 8. Is a consultant certificate binding? Well, the law on this subject is just all over the place. In my book, I think I have over 60 cases dealing just with this issue. That is, what is the effect of a certificate on a construction program, be it a certificate of partial payment or completion or whatever it is. Of course, you can have certificates for all sorts of things in a construction project. But the law is never clear, or the law is not consistent, I would suggest, through those 60 cases. Some cases you see judges saying, certificate's binding, can't go behind it. Some say, well, some say it's binding. Read the rock construction case. The parties are bound by the certificate, even if they have errors, unless there is conduct on the part of the owner or the payment certifier that would make it inequitable to rely on the certificates. In the Noble Star case, the master held that the certificate was reviewable on an arbitral standard and only set aside if it's patently unreasonable. In Demcon construction, the court said, no, it's just a piece of evidence. The payment certifier certified this, but the arbitrator or court can go behind that and make a correct finding, and it will use the certifier's certificate simply as a piece of evidence. So this law is, in my view, confusing, and I'll say 6 principles that I think you should have regard to. The first is, if the contract says that the certificate is final and binding and not subject to any appeal whatsoever, then it is. But my question to you be, why would you ever put that into your contract? Why would you ever put that the certifier, even if he's dead wrong, his judgment is to be binding? I don't think you should. And the CCDC contract, as we'll come to the end, does not say that. Second, in most contracts, you are required to protest against a certificate. And if you don't protest, then the certificate can be binding. But if you do protest and notify, then it's not. And the famous Corpex decision in the Supreme Court of Canada is probably the most famous case dealing with the failure of a contractor to notify of his complaint about a certificate. So you've got to do that. You've got to notify if there's a notification requirement. Third, if it's an interim certificate, then it may be that the certificate is binding for the purposes of the actual payment being made. Because you need to have, during the course of a construction project, an ongoing flow of funds. So the certificate may be binding for that purpose, but not for finality. Fourth, a final certificate is more likely not to be binding. The parties are presumed to want, in their final contractual dealings, their final payment dealings, to have a correct reconciliation. So I think the law would support the proposition that a final certificate is more likely to be reviewable than a interim payment. Fifth, remember that certificates can be issued by a consultant for many purposes. Additions to the contract, concealed or unknown conditions, delays, changing contract price, termination. There's all sorts of circumstances in the CCDC contract. Those that I just referred to are in GC 6.3 through GC 7. So in each case, you have to look very carefully at what it is that is to be certified. And in most of those circumstances, I think it's unlikely that or it should not be presumed that the parties intended that a certificate be final and binding and not subject to review. And again, when you're drafting such a contract, think about it. Why would you want such a certificate to be binding? And sixth, I think the CCDC contract comes down right on this issue. It says that the consultant certificate is in the first instance, the consultant is in the first instance to be the interpreter of the contract, subject to the dispute resolution clause. Second, it says that the parties retain their rights in addition to those found in the contract. That's CCDC GC 1.3.1. And third, there is a dispute resolution clause which is clearly built on top of the consultant's powers. And the consultant's powers are built right into the dispute resolution clause, which I think makes it pretty clear that the dispute resolution clause is there as a final right of the parties to object to a certificate wrongly issued. So those are the 6 principles I would take from those, from that area of the law. All right, another area of the law in which the law is very confusing and contradictory, and that is incorporation by reference. Will a clause in the main contract be incorporated into the subcontract by an incorporation by reference clause? Now, this can occur in many areas of construction law. The bond may say that the contract is incorporated into it. So we have all sorts of contracts in a construction law setting in which incorporation by reference may be an issue. But the most common one is a subcontract saying that the terms of the main contract are to be incorporated into the subcontract. And the law here is I think you can figure out the law if you apply what the previous speaker said about common sense. Did the parties really intend by their incorporation by reference clause to incorporate something from the main contract? Now, does that make common sense? I think is a good a good test. So probably not when it's a clause requiring specific notice of a claim. And the Corban case said the subcontract did not incorporate the notice of claim provision in the main contract into the subcontract. In the Smith and Johnson case, Ontario court held that specific and unusual powers of the engineer contained in the main contract were not incorporated, even though there was a clause in the subcontract that said all the terms of the main contract are incorporated. Court held no, that does not apply with respect to specific or unusual powers of the consultant. Dispute resolution clause in the main contract will not usually be incorporated into the subcontract unless there's specific reference. But I can tell you there's cases to the contrary. But I think the common sense of it is that the kind of resolution that the owner and the general need is a different kind of resolution, or may operate differently as between the sub and the contractor. So unless it's clear, the dispute resolution clause in the main will not be incorporated into the sub. But probably, yes, it will be, which with respect to things that relate to the actual conduct of the work. You're dealing with the specifications, you're dealing with the drawings, you're dealing with specific change directions, specific work practices, will probably be incorporated by a general incorporation by reference clause. Standard type of clauses will be, like a force majeure clause may well be incorporated, as was the case in the Litchfield case. So it's a minefield, I think. There's cases all over the way, but I think if you can apply some sort of logic and common sense to the process, and I guess the better point to make is, why not deal with this thing up front? Why put in a general clause? I know they're in most clauses, but why don't you just say the incorporation by reference applies to these particular provisions in the main contract, and put your mind to it? What do I want in the main contract to be incorporated into the subcontract? If you do that, I think you're going to end up with a better product and a less confusing product than if you simply say everything in the main is incorporated into the sub. All right, Betterment. I did a mediation where this was a huge issue, so it just got me focused on the law of Betterment. It's something that you probably won't run into all that much, but it's a really indigenous part of construction law, isn't it? The owner sues the contractor and claims all sorts of monies to repair the damages. Contractor says, oh yeah, but you ended up with a better product than the one I agreed to build for you. You can't claim all those monies against me because that's Betterment. And the question is, where does the line get drawn between what is Betterment and what is not? And there's 4 or 5 areas of interest here, I think. First of all, a performance-based specification, which was the case in the mediation that I did. In other words, it's not a product, physical products described, it's a performance that's provided in the contract. And the owner in that case says, well, I'm getting no better performance out of this. It may be flashier, it may be da-di-da-di-da, but it's the same performance that you agreed to give to me. So I don't have an answer to this. It's going to depend on the facts of the case, but watch out for performance-based specifications. They may provide an owner a better opportunity to recover fancy and costly repairs than the contract. And a contractor who was underbid and promised a certain performance for a very low price may find that the damages are assessed on the basis of what you promised to perform, notwithstanding your very low bid. A second issue is if the owner had no reasonable option in the mitigation process than to do what it did, then there are cases out there that say that, well, it may be better, but that's what the owner was entitled to do because that was the only way to fix the problem. In that case, the owners have been entitled to recover betterment in that circumstance. And similarly, there are cases that would say it would be unfair for some, and there are various reasons where the courts have said, yeah, it's a better product, but you're going to pay for it, contractor, because it's unfair to make that deduction from the owner's claim. A third situation, which you will see in the cases, is no gain from the betterment. So if the betterment has occurred, but the owner is not going to gain from it because, for instance, it's agreed to sell the property, and therefore it's not going to reap any benefit, courts have held that the owner is entitled to recover the benefit. Or if there are other damages at play, if the owner has suffered in other ways, such as a delay in completing the project, there are cases in which the court has said, you know, this is a wash. I'm not going to give you a reduction by reason of betterment because of all of the other factors. And the court can say, I can't figure it out in dollars and cents, but there's swings on each side, and I'm not going to reduce the amount due to betterment. So 5, builders' risk policies. And I'm sure you're going to get a lecture this week on builders' risk policies. It is a very, very difficult area of the law. And I just wanted to bring these 2 cases to your attention, Leadcore Construction and the Acciona case, because to my mind, it is very difficult to resolve them. One of the Alberta Court of Appeal, Leadcore, and BC Court of Appeal, Acciona. In Leadcore, at the end of the project, they bring in people to clean the windows of the building, and they scratch all the windows. And the contractor makes a claim saying, well, this is damage to the work, and I'm entitled to recover under the builder's risk policy. Alberta Court of Appeal said no. It's not. It's exempted under the exclusion for faulty workmanship. In the Acciona case, it was a concrete slab, and they built the frame and they built the forms. They put frames and forms around, and then they poured the concrete and put in the rebar, and the frames and the form were erected in such a way that the concrete bent, and it broke the rebar inside, and it ended up with a floor like that. And they had to shave the whole thing off. It cost millions, tens of millions of dollars to get it. It was a hospital building, so they had to get it back so that people weren't going like that throughout the hospital building. Claim was held to fall within the contract, and the faulty workmanship exemption did not apply. They're very difficult cases to reconcile. It seems to me you can go under a builder's risk policy and flip a coin and see what happens. Now, you can rationalize it on a factual and legal basis, I think. They were different facts. In both cases, it's an impact on the structure by one at the end of the project scratching the windows, and the other before you build the form work, the forms and the construction around the concrete that's going to be poured in. So you could say the cleaning of the work, when you're actually physically putting your hand on the window, that's faulty workmanship. The Court of Appeal of Alberta said the scraping and the wiping motions that caused the damage were the actual work. The damage was not accidental or fortuitous. The scraping and wiping forces that caused the damage were intentionally applied to the windows as a core part of the work to be done. Therefore, they said the work was excluded under the faulty workmanship exclusion. But in Acciona, the frames and the shoring was in place before you put the concrete in, held to be covered, not excluded by faulty workmanship. Different policies. The Leadcore policy contained the resulting damage exclusion, and the in the Accioni case, the insurer had quite a different kind of exclusion based upon factors relating to the work being done properly as opposed to improperly, rather than a resulting damage kind of clause, which these clauses normally are. Perhaps you can explain the difference by that difference in the clause, but fundamentally, in my view, courts are not clarifying, at least to my understanding, exactly why you are inside or outside the exclusions in a builder's risk policy. Don't have an answer for you, but just read those two cases because I think that they are very important recent cases. What constitutes lienable services in relation to an improvement? The recent decision of the Saskatchewan Court of Appeal, again, a case that I have great difficulty in understanding. Basically, the Court of Appeal of Saskatchewan held that services, this is a lien case, these are lien issues here we're talking about, that services in relation to an improvement can be lienable even if the improvement is not itself an improvement. So these were tanks put on tanks that were installed on a oil property, development property, and the person providing all the services in relation to these tanks claimed a lien against the land. And the Court of Appeal held that it was entitled to the lien even though the tanks could be removed and moved away and were not an improvement, on the basis that it is a mistake to begin and end the inquiry with whether the storage tanks are an improvement. The issue is whether Grey Owl provided services on or in respect of an improvement for an owner, contractor, or subcontractor, and as part of this analysis, identify the improvements in question. This approach focuses on the main contractor contracts rather than its individual subcontracts and the work being done under them. So if somehow you can say that these services, although in relation to those tanks, are also in relation to the overall project, which is an improvement to land, the services get to be lienable. I must say I can't understand that because what it does, it places the person who puts the tanks on the land in a different position than the person who provides the services to those tanks. And why should that be so? I mean, Section 2 of the Saskatchewan Act and all the other acts say that an improvement is a thing except a thing that is not affixed to the land or intended to become part of the land. That's the exception. And I don't quite understand why that exception doesn't apply to the services as much as it does to the land. But and whether that case will be followed and applied in other provinces, it only came out in October, so we'll have to hold on to our seats and see. Okay, third issue. And this is one that really troubles me, and maybe you people understand it better than I do, but I think there's been developed in our law a fundamental disconnection between an owner's representations as to whether something is buildable or not. And now our old law, so the question is, does an owner impliedly warrant, represent, or have a duty of care to the contractor that the work set out in the specifications or drawings or whatever can be carried out or the result achieved? And is the answer the same regarding specifications and drawings? Well, the old English law found in the Thorne case is that an owner does not impliedly warrant that work can be done in accordance with the specifications. That's old English law. Now, one could say that that law developed before Donahue and Stevenson was ever thought of, before we developed tort law. Be that as it may, that is the way English courts looked at and maybe English courts in those days were protective of owners more than contractors. I think all of those factors play into the Thorne case. In any event, it's been applied and adopted in Canadian cases that by specifying something, the owner doesn't necessarily warrant that it can be built. It's up to the contractor to look at those specs and say, yeah, this can be built. So that's one line of cases. The other line of cases now is developing out of the Edgeworth construction case. You remember that case where the engineers were held liable in negligence in respect of their drawings of a bridge. The Supreme Court of Canada said that the plaintiff could recover against the contractor, and because it was represented by the drawings that what was there could be built. Well, now that's been adopted in two Ontario Court of Appeal cases in respect of the owner. And for instance, in Osgoode, the Court of Appeal said, we agree with the appellant that tender documents represent an implied representation to the compliant bidders that the work described in the tender documents could be built as described. Those bidders are entitled to rely upon the accuracy of design information prepared by the owner or its engineers. A bidder does not have to duplicate design and analysis prior to submitting a bid. Now, maybe all of you will be smarter than me, but I am having and I've had arguments during mediations about this, or not arguments, I'm just the mediator, but discussions as to which body of law is to apply here. The traditional old law that the owner makes no representations and it's up to the contractor to figure it out, or that the drawings and specifications do contain an implicit representation that what is contained in them can be built. We're going to need, I think, some high court to sort this all out. Second last issue, trust funds and lien bonds. And we now know, and you're probably going to hear about the Stuart Olson case this week, so I won't spend too much time on it, but the Supreme Court of Canada has now held that after a lien has been discharged by a lien bond, the owner must continue to comply with its trust fund obligations and cannot sort of throw up its hands and say, well, I've got a lien bond and that's the end of my trust fund obligations. That's not the case. The Supreme Court of Canada basically said these are two different regimes. One is a lien on the land regime. One is a trust fund with respect to the monies paid under the project regime. And neither of the twain shall meet, or satisfying one does not satisfy the other. Interestingly, in Manitoba, these two obligations, the lien legislation and the trust fund obligation, came originally from two different statutes. So it was easy for the Supreme Court to say, these are two different regimes. They came from two different statutes. The mere fact that they're in the Builders Lien Act in Manitoba doesn't mean that one trumps the other. That's not the case in all provinces. In Ontario, the two rights have been in our Act for a long period of time. So whether an Ontario court would arrive at the same conclusion, I think it should. I don't think that the provision of a lien bond should eliminate the ongoing obligation of the owner to comply with its trust fund obligations. But it's going to be an issue in other provinces because the Supreme Court decided this in part based upon the particular statutory history in Manitoba. It's interesting that, you know, the trust fund obligations and the lien bond obligations are not the same in all provinces. In Alberta and Ontario, all subcontractors, if you pay money into court to discharge a lien, all contractors can share in those monies. But that's not the case in Saskatchewan. Saskatchewan, it's the person whose lien is discharged that is entitled to those monies. And in Manitoba, New Brunswick, and PEI, those persons are entitled to at least a first charge in those monies, even if not exclusively as in Saskatchewan. So these statutes are not the same with respect to lien bonds. And similarly, the trust fund obligations don't start at the same level. In Alberta, they start at the contractor level. In other provinces, they start at the owner level, like Ontario. So we cannot be certain that the decision in the Stuart Olson case will apply in all provinces and that the logic of its and it's, the logic of that decision should apply in all provinces, although it does seem to me that the better argument is that the two are distinct, and that the owner should not be entitled to stop its trust fund obligations simply by providing a lien bond for those liens that have been registered. So we're running out of time, I think, but let me talk lastly about the subject that
20 minutes.
I'm behind here. Okay, honest performance. This is everybody's favorite subject, and it really is going to be so interesting in the construction law field to figure out how Bazin and Heintzman will be carried out. What the Supreme Court in Bazin and Heintzman said is there's an underlying principle of construction law in Canada that you shall act in good faith. It's not an implied term, it's an underlying principle. But in the contract, there is a term that you shall perform the contract honestly, whatever that means. And the court said you cannot contract out of that obligation. You cannot contract out of the obligation of honesty in the performance of a contract. Well, I think this is going to cause us to go back and revisit a lot of the case law to see whether the result would have been different, or the result that was achieved can now be explained on the basis of honest performance. The first thing I think we should do, we should all look at the law of Quebec, because the Quebec Civil Code has had an obligation of good faith in it forever. There is an obligation of good pre-contractual good faith in the law of Quebec. There is an obligation of good faith in the performance of contracts in the law of Quebec. So they've had to deal with this issue for years. And the case law that has developed will assist us, I think, in the common law provinces to understand this issue. But let's take a few examples. A gentleman this morning said, delivering a schedule. Let's assume that the schedule that the contractor delivers, he knows to be impossible to meet. He knows that he knows he can't meet that schedule, but he's counting on. He's looked at the contract. He says, "There's so many changes that are going to be needed here that I'll get that time out of change orders." Is that honest performance? Or a lowball bid to a tender, knowingly lowball the bid, or recklessly lowballing the bid in the hopes of making claims for extras? Or, and this is one of the cases from Quebec, requesting a contractor to perform extra work with all sorts of assurances and beautiful words, and then relying on the strict wording of the contract to say, you didn't get that change order signed. Or failing to pay monies under the contract for ulterior motives. You know, a weak contractor. Again, that was part of the reasoning in the DOCO and construction Kiewit cases. So those are all sort of circumstances that I think we're going to be seeing litigation about, and we're going to have to be advising our clients. You know, can you, maybe in the old days you used to be able to do that, but not since Heintzman and Bazin and Heintzman. You can't do that because it's really dishonest. It goes beyond the bounds of reasonableness into something that simply is dishonest. In DOCO, the Court of Appeal said these two claims are essentially based on allegations of a single fault, that the uncompromising attitude and lack of cooperation of Hydro-Quebec during the performance of the contract and subsequently caused DOCO financial difficulties and other serious drawbacks, etc., etc. Said, without doubt, we can abuse rights under Articles 6 and 7. Those are the articles of the Quebec Code, without having committed a serious or intentional fault. But the fact remains that not everything which in retrospect proves to be a breach of contract deserves to be labeled as abusive. So Court of Appeal of Quebec said, look, at the mere fact that you breached a contract does not mean that you have been dishonest. Where that line gets drawn gets pretty difficult, doesn't it? In Kiewit, the court said, the judge concluded that Hydro-Quebec demonstrated institutional bad faith by making Kiewit believe it would get fair compensation on submission of a detailed request and refusing it thereafter. Hydro-Quebec did not act with transparency. And going on, I said, this in no way relieves the parties, the developer as much as the contractor, from respecting the rule that good faith must govern their conduct at the time of the performance of the contract. And the court went on to find that by the use of their beautiful words, I love this, making reference in paragraphs 160 and subsequent to a letter of Hydro-Quebec representative dated June 28, 2001, in which this commitment was made, the judge qualified it as an example, among others, of beautiful words by the developer to divert the problem as experienced by the contractor on the site. These were beautiful words that were used to appease the contractor, who had to commit significant sums to deal with situations over which he had no control, and most importantly, which he did not largely create. So I think we're going to see a lot of that kind of consideration by courts and arbitrators under the Baz and Arinu case in the common law provinces now. Another thing I think we're going to see is we're going to see courts going back and looking at existing situations in a different way. Though the urban kind of building group's case is one in which the contract was terminated with 2% on the contract to go. And the contractor said, how can that be a fundamental breach? I had 2% to go, and you terminate me for a fundamental breach of the contract? It's not so. And the court in that case upheld the contractor's position and said, the onus was on the owner to prove that it had a right to terminate the contract, and had not proven that. I think today we're going to see contractors say that was a dishonest termination of the contract. And now how you prove dishonesty, we're going to be getting a lot more examination for discovery into emails and conduct and motives and all that sort of thing, and a reasonable basis to so act, or recklessness to so act. A lot of that is going to become much more relevant now that honesty is a factor. So those are my 10 top 10 issues that are on our radar screens right now.